question presented to the court today is whether invalidating a generally available and religiously neutral student aid program simply because the program affords students the choice of attending religious schools violates that free exercise clause of the First Amendment.
In 2015, the Montana legislature created a tax credit program that would incentivize corporations and individuals to donate to nonprofit private scholarships that would benefit high school students within the state. A while after, the Montana Department of Revenue enacted Rule 1 in order to comply with the Montana state's constitution, which established that students who attend a school or institution that promotes a religion could not be awarded the scholarship. The petitioner, Kendra Espinoza, a mother of a low-income household in Montana, applied to receive a scholarship so that her children could attend Stillwater Christian School, located in Kalispell, Montana. Without the scholarship, they would not be able to afford to continue their education at Stillwater. Seeing that Rule 1 violated the free exercise clause, Espinoza sued the Department of Revenue in state court, wanting to challenge Rule 1. The lower court found that the scholarship program was constitutional without the addition of and found in favor of the petitioner. Once it was appealed, the Montana Supreme Court reversed the ruling, finding in favor of the Montana Department of Revenue, and argued that the scholarship program is unconstitutional without the addition of Rule 1. We contend that the Montana Supreme Court's decision restricted Espinoza's First Amendment right to the free exercise of religion. In his Thanksgiving Proclamation of 1789, George Washington calls for Americans to, quote, promote the knowledge and practice of true religion and virtue, unquote. However, the current and general sentiments in today's age do not reflect the words spoken by Washington years ago. Instead, Americans who are religiously affiliated are discriminated against.
So, Counselor, can I ask a question, please, before we get too far into we'll get back to Washington in a bit. Do you see this case primarily as a free exercise case or an establishment clause case? How do you primarily see this case?
Thank you for your question. We actually, I think a major theme in this case is this fact of that we have to balance the concerns of the establishment clause of the First Amendment with the free exercise clause of the First Amendment. And throughout our case, we contend that the Montana Supreme Court's decision skewed too far in terms of trying to uphold the establishment clause at the expense of violating the free exercise clause.
Well, let me ask you a follow-up if I can. Was Montana obligated to provide any funding for religious schools? Are they required to by any sort of law?
There's no current law that I am aware of that requires them to provide this funding.
So why can't the state withdraw that funding to avoid an establishment clause violation?
The reason that the Montana Supreme Court stated in their decision to invalidate the scholarship program was that it violated a section of their state constitution, because that section of the state constitution, we contend that application of it violates the free exercise clause. The invalidation of the program also violates the free exercise clause.
So, are you asking this court to declare the Montana Constitution unconstitutional? Is that what you're asking? To declare the Montana Constitution invalid? Is that what you're asking us to do?
Well, I think what we're trying to ask you to do is specifically in similar applications of similar clause of like this clause in the Montana's constitution, like that's application should be declared unconstitutional.
And Counselor, can you tell me, are there other states in the United States that have similar laws in their books, these sorts of provisions?
There are around 30 to 40 states that also have similar amendments.
So you're asking us to declare 40 state constitutions unconstitutional. Is that what you're asking us to do?
Well, in their application of such amendments to their constitution to funding for religious programs.
Oh, that's a tall order, but okay. All right, carry on. You can continue with the argument, please.
Yeah. Instead, Americans who are religiously affiliated are discriminated against, even though their country was founded on the belief that religion and government could coexist without affecting one another.
The Blaine Amendment provides crucial historical context to our discussion of the case today. In 1875, Representative James Blaine proposed a joint resolution to prohibit states from providing governmental aid to religious educational institutions. The Blaine Amendment failed in the Senate, but inspired 38 states to adopt similar provisions in their state constitutions. Montana was one such state, ratifying Article 10, Section 6, Clause 1, titled Aid Prohibited to Sectarian Schools. In 1889, as the court acknowledged in Hunt v. McNair and Locke v. Davie, the word sectarian was a euphemism for Catholic and was strongly associated with anti-Catholicism. Though Blaine amendments, like Montana's, ostensibly codified the separation of church and state, their true intent was to maintain Protestant influence over education and to ostracize the private school system created by Catholic influence.
If I can interrupt just for a second, I'm with you. Blaine hated Catholics. I agree. And I think a lot of these amendments in the 1870s, I think Oregon probably had one as well, if I had to guess, where you guys are from. I will agree that the history of this has a lot of anti-Catholicism. I'm going to agree with you on that one. But the Montana version was enacted, what, in the 1970s? Pretty recently?
I believe in 1889.
In Montana?
Article 10, Section 6, Clause 1.
Okay, well, put that aside for a minute. What if, even though there was some anti-Catholicism in the past, why can't we say that today Montana has this rule to avoid Establishment Clause violations? Right? Couldn't there be a different intent now than there was 100 years ago?
I think that, sure, like we can, I wouldn't presume to know the specific intents of policymakers in Montana, but what we do know is that this amendment does have a very storied past, and that provides crucial historical context, especially when we're looking at the invalidation of a program that could have been accessible to religious schools.
Well, you know, you mentioned Locke v. Davie. Can one of you tell me what that case was about, please?
Locke v. Davie is about how a Davie who wanted to become a minister applied to do so, wanting a scholarship to go to school to become a minister, and he was denied that scholarship because the court found that it was a religious endeavor, and that by sponsoring his quest to become a minister, that would be a direct way for the state to promote religion. Okay,
so in this case, if I can ask, what were the scholarship money being used for?
In Espinoza?
In Espinoza, exactly. What was the scholarship money being used for in Espinoza?
The scholarship money was going to students who couldn't afford to go to private schools, and it wasn't just religious schools, it was any private school they wanted to go to within religious schools.
And could the money be used for religious studies at these religious schools?
Technically, yes. However, at those religious schools, they were not only teaching them religion, they were also teaching other subjects.
I get that. And let's say at the beginning of every class, you know, you're studying math or history or science, mm-hmm. and they say a prayer at the start of every class. Would the state money be used to cover that prayer at the beginning of class?
Indirectly so. But the distinguishing it from Locke v. and Locke, that money in the scholarship would be directly used for sponsoring a minister and directly sponsoring religion versus these scholarships towards the students. In the case of Espinoza, it would be indirectly sponsoring that.
Well, what's the best case in your mind for your side of the case? What's the strongest Supreme Court precedent that you have?
Most likely Trinity Lutheran v. Comer.
Okay, so tell me about Trinity Lutheran. What was going on in that case?
In that case, Trinity applied to get a scholarship program to help build their playground, and that they were denied that money in order to do so, which because they were a church. And the court struck that down and said that that was furthering the Establishment Clause to a point where it violated the free exercise of religion, and that couldn't happen.
But in Trinity Lutheran, didn't the majority opinion stress that we're dealing here with a playground, and that having these rubber chips in the playground would keep everyone safe, that there wasn't really any sort of religious significance to having a playground? Isn't that different from your math or science class where they begin a prayer, they say the Lord's Prayer before they do the periodic tables? I mean, isn't there a distinction between a playground where kids are scraping their knees and a class where there's going to be religious instruction at every juncture?
Well, we believe that the primary intent of these scholarships was still to ensure, to promote education, access to education for all as a whole. And here we can look to Mueller v. Allen, where the court, in its opinion, stated in Mueller v. Allen, the issue was a Montana tax deduction for educational expenses, and in the opinion, the court stated that these tax deductions had the secular purpose of ensuring that the state's citizenry is well educated, as well as of assuring the continued financial health of private schools, both sectarian and non-sectarian. And we believe that the scholarship program in place in Montana had similar goals.
Well, tell me about Zellman. All right, is this case similar to the vouchers in Zellman?
Yes.
How so?
In Zellman, there was an Ohio program that provided school vouchers, and the key similarity between Zellman and Espinoza is that both programs are true private choice programs. The government is supporting education, and whether or not that education is religious or non-religious, that decision is made by private individuals, both in terms of the people who actually donate to the scholarship organizations by the scholarship organizations themselves, in terms of which scholarships they fund, and in terms of whether a parent decides to use that scholarship for religious or non-religious.
But Counselor, in Zellman, wasn't there a requirement that the vouchers not be used for any sort of religious studies?
Well, I am not aware of that exception.
Okay, well, just take a hypothetical, right? Why couldn't Montana rewrite this policy and say, this money can be used for math or science or history, but it can't be used for religious instruction? Why couldn't Montana write that specific statute?
Because at the K through 12 level, most of that the funding for that type of education, when we're looking at scholarships, is hard to distinguish because students receive a whole gamut of educational
classes. Why not? But you can limit it. You could say, this can be used for buying books for science and math, but you're not going to buy Bibles, right? Why couldn't the state do that instead?
They probably could, but in this case, because they decided to create this scholarship program, this generally available scholarship program,
maybe that's a problem. Maybe
the
generally available policy maybe runs afoul of the state constitution, but they can do a specific policy that wouldn't. Why isn't that the answer?
Well, given that the Montana Supreme Court has already handed down their decision, at this point in time, there's no feasible path to go back and ask the legislature to reconsider.
Sure, there is. We say their policy is unconstitutional, and they can start over from scratch. And you have about 45 seconds left, so you could also work in your conclusion as well, if you like.
Sorry, was there a question at the end of?
Just go ahead and get to your conclusion. You have about 30 seconds left.
Okay, sure. So the intent and effect of the original Blaine Amendment and the modern application of it are the same: to deny parents, children, and other interested parties their First Amendment right to freely exercise religion. This court should reverse the judgment of the Montana Supreme Court and strike Article 10, Section 6 of Clause 1 of the Montana Constitution as applied by the Montana Supreme Court.
Okay, thank you very much, Counselor. All right, 15 minutes for the respondents. We have Elliott and Lance. You can do whenever you're ready.
Okay. May it please the
that I, Elliott, Lloyd, and my partner, Lance Pancoast, represent the respondent, Montana Department of Revenue, in the case Espinoza versus the Montana Department of Revenue. The question presented before the court today is, does it violate the free exercise clause to invalidate a student aid program simply because the aid program offers students the choice of attending religious schools?
Here are the facts of the case. The 1972 renewal of the Montana Constitution created a provision that prohibited aid to religiously affiliated schools. This provision was created in order to strengthen the public school system and to ensure separation between church and state. Yet in 2015, the Montana state legislature created a tax credit program that would provide $150 tax credits to donors who gave to private scholarship organizations. 94% of these scholarships went towards religious schools. In order to comply with Montana's state constitution, the Montana Department of Revenue issued Rule 1, which excluded religious schools from the scholarship program. Petitioners claim that Rule 1 unconstitutionally excluded them from the program. Thus, the Montana Supreme Court decided to invalidate the tax credit program, resolving these claims. Today, we will argue the Department of Revenue's invalidation of the tax credit program does not violate the free exercise clause.
Today we will talk about Locke v. Davie and show that it is permissible to exclude certain categories of instruction and that there is room to play within the joints between the Establishment Clause and the Free Exercise Clause. Secondly, we'll take a look at the original intent of no-aid clauses and the thoughts in founding America at the time around no-aid clauses and aid to religious schools.
Okay, Counsel, let me, if I can interrupt for a minute. Let's start with the point your friends on the other side made about Senator Blaine. I think we can all, yeah, I think we can all agree Senator Blaine didn't like Catholic people. I think we could all agree with that much. Does the fact that there's such a strong anti-Catholic history here affect our analysis of the Montana Constitution?
If I may.
Please.
No, it doesn't, because in the 1972 renewal of the Montana Constitution, this was a time when they called the convention and they looked at what they were adding to their constitution and seeing how it fit up with the values of 1972, not the values of 1880. So when we look at this 1972 no-aid clause, I think it's really different from the earlier Blaine amendments of the 1880s. In fact, in 1972, many religious leaders spoke out in favor of the no-aid clause, including a Catholic priest, because they felt the no-aid amendments would in fact help protect religious liberty by ensuring the separation between the government and the religious institution and ensuring that there wouldn't be any sort of governmental control when it came to religious institutions. So though I do agree that yes, some Blaine amendments definitely do have this anti-Catholic sentiment, I think when we're looking specifically in this case at Montana's no-aid amendment, that just isn't the case here.
And Lance, I'm sorry if it was open crosstalk. Was there something you want to add?
Oh no, I was going to say the exact same thing.
Okay, good. Well, I'm glad you're on the same page. Well, let me ask a follow-up question then, right? Do you see this more as an Establishment Clause case or as a Free Exercise Clause case? And this is for either of you two.
Elliott, do you want to take this one?
No, you take that, Lance.
Okay. So this is definitely more of a Free Exercise Clause case, and the reason for that is actually, Elliott, do you want to take this one?
Sure, yeah, so I definitely think it's more of a Free Exercise Clause case because like we were talking about Locke v. Davie, if you look at Locke v. Davie, we see that like Montana, Washington has a similar type of no-aid clause that prevents funding from going to religious schools. And Locke v. Davie says that yes, like this, you can have programs that offer student aid under the Establishment Clause. You may, states are allowed to do that. But the crucial thing from Locke v. Davie is it shows that states are not required to do so under the Free Exercise Clause. So I think what we're really looking at here in Montana is that this is a Free Exercise Clause case because we're not arguing about whether or not the program can exist. What we're arguing about is invalidating the program. And Locke v. Davie shows us that it is entirely possible to invalidate the program because we're not required to do so under the Establishment Clause.
All right, let me, if I can, ask a follow-up question. Maybe this one for Lance. We try to get the crosstalk. And by the way, it's completely understandable with the crosstalk. This is not normally how we do things. Usually you're in the same place, so you guys are doing the best job you can. So Lance, let me ask you this question. We discussed Trinity Lutheran, right? It's a fairly recent case. It's a couple years old. Your friends on the other side think that Trinity is the case strongest in their in support of their case. Lance, tell me why is Trinity Lutheran not? Why does the case not hurt you? Doesn't that case weaken your argument?
Yeah, Trinity Lutheran is actually a fairly weak case when we consider it in this situation. So the fact pattern was that an elementary school controlled by Trinity Lutheran Church was denied a grant for a rubber tire surfacing. And the court ruling was that it violated the free exercise clause to not give a generally available grant for rubber surfacing of the playground. But the key distinction is that Trinity Lutheran was incorrectly denied rubber on its status as a religious institution. The grant itself was only going to go towards the secular playground. There was no religious, the money could not be used for a religious intent. And that's the distinction.
Okay, well, let me interrupt you for a second, right? In Trinity Lutheran, the court said you can't target an organization because they're religious, right? Wasn't that the basic holding? Because they're religious?
Yes, that is correct.
But aren't you denying the scholarship here precisely because these schools are religious? Isn't that exactly what Trinity Lutheran said you cannot do?
I believe the question you're asking, so are you asking that, does that fact pattern hold in the current case we're discussing?
No, here's my question. Trinity Lutheran said you can't discriminate against a school because it's religious.
Right.
That's exactly what's happening here. If this was a secular, private school that was a military academy or something, there'd be no issue. But because it's religious, they're being denied these scholarships.
The distinction is that while Trinity Lutheran was denied on its status as a religious institution, the money in the Big Sky scholarships could be put to a use as a religious funding. There was no provision that expressly forbid the use of the fundings for religious purposes, which in the case Nyquist, Committee for Public Education and
Wait a minute. But as I understand it, under the Montana Supreme Court's ruling, $0 will now go to these religious schools. Isn't that just, there's no money that goes to these schools? What funding is allowed under this current regime?
There's no funding that would be allowed to go to religious schools, but that doesn't necessarily mean, but states are allowed to discriminate on religion. Because there was no provision that was, that expressly forbid the funding to go to religious purposes, the funding could be used to, say, refurbish pews or buy religious texts. And Locke v. Davey, in Locke v. Davey, as my partner previously said, the ruling said that you're allowed, there's some playing within the joints, and that the states can offer scholarships under the Establishment Clause to religious institutions, but they're not required to do so under the free exercise clause.
I get that, and maybe your co-counsel wants to chime in, but I'm not getting how you're getting past Trinity Lutheran. Trinity Lutheran says you can't discriminate on the basis of religious status. Isn't that exactly what's going on here?
Can I introduce another case that I think is a perfect counterpoint to Trinity versus Lutheran?
Oh, please go ahead.
May I?
Yeah, go ahead.
Okay. In the Nyquist case, Committee for Public Education and Religious Liberty versus Nyquist, a generally available aid, the ruling was that a generally available aid can be given to religious educational institutions as long as the fundings are not used for religious activities or upkeep. The court noted that the grant in the specific case could not guarantee the separation between secular and religious education functions. And because of the lack of distinction, the grant that was considered in the case was banned. So, in this case, we can clearly see that because the funding could not be separated from secular education and religious education, that was the reason why the funding was banned. And it's the same in this case. There's no provision in the Big Sky Scholarship and in the grants such as Big Sky Scholarships that expressly forbids the funding to be used as explicitly secular. So the funding could be as I've said before, could purchase religious texts, and that would violate the precedent set by the Nyquist case. Does that answer your question?
Perhaps, Elliott, I think you might want to add. Yeah, you've been seeing trying to get in.
Yeah, I just wanted to note about you made a remark about now that maybe religious schools would have no state funding in Montana. I'd just like to point out that even if this tax credit program, when this tax credit program is invalidated, the religious schools still have plenty of opportunities for state funding. Individual donors can still get tax deductible status on their donations to religious schools and things like that. So even though the funding from this scholarship is not available anymore, there's still funding to available for religious schools.
Well, let me ask you a follow-up question, if I can.
Yeah.
The tire scrap program at the church,
Yes.
right, at the playground, I think we can all agree that tire chips are not religious in nature, right? I think we can all agree on that
Right.
much. But think about what the tire chips do. They are making that playground more attractive, right? They hope that people will want to send their kids to this playground, and if they send their kids to this playground, they'll also get some religious instruction, right? Isn't the existence of these tire chips going to directly expose kids to religious instruction? I don't see how maybe you can reconcile Nyquist with Trinity Lutheran, but how do you reconcile those cases?
I think as for Trinity Lutheran, the fact about maybe that, yeah, I can agree that maybe having tire scraps at a playground would make the school a little bit more attractive. But I think that comes down to individual choice. And there I'd like to look at Zellman-Harris. And because you see in Zellman-Harris, the ruling from the court says that governmental assisted, like generally available aid is allowed when the government aid is directed to religious schools wholly as a result of their own genuine and independent private choice. And I think that's what's happening with the tire scraps in Trinity Lutheran. That yes, if it does make the church school more attractive to individual parents, that aid is reaching the school a result of individual private choice, not direct governmental aid. And that's different in Montana because this is going straight to the religious education. This is not just individual private choice. This $150 tax credit is essentially a one-to-one donation, which is this indirect aid from the state that the Montana no aid amendment to the Constitution does prohibit. So the only choice for the court was to invalidate the program.
Can you proceed? Yeah, and you have about 2.5 minutes left.
Awesome. We just also like to point out that the original intent of no aid clauses was made by the founding era philosophers such as James Madison and Thomas Jefferson, who had very philosophical reasons for the why no aid amendments and such were actually necessary for ensuring religious liberty in our nation. In James Madison's Memorial and Remonstrance Against Religion, he speaks about how having governmental control in church establishments, instead of maintaining the purity and efficacy of religion, actually have a contrary operation. And this is the same logic we actually saw in the 1972 renewal of the Montana State Constitution. So we've seen here that the Montana State Constitution is in line with the original intent of the founders, such as James Madison or Thomas Jefferson, who wants a wall of separation between the church and state.
How does denying a religious school funding help religion? Maybe you can connect the dots for me. How does blocking the school from having funding help the religious school?
I think that would go back to maybe Lemon v. Kurtzman and looking at the Lemon test and avoiding this excessive entanglement with
No,
school
I get
and
the Lemon
religion.
test to avoid entanglement, but how does avoiding entanglement help religious? Wouldn't it help the school to give them more money?
Well, no, because then what if they have to reapply for the funding? They have to make sure that the funding isn't being used like we said in the hypothetical earlier. What if this funding is used just for secular subjects? How would you find that out? And then this creates this prolonged relationship. Having that funding there can also be used as a lever, perhaps, to coerce the church into doing certain policies and making the state say, all right, well, we'll give you this funding, but only if you stop saying a prayer at the beginning of each class. And so in order to protect the right of the religious institution to instruct in the way that they want to, it's important just to have this wall of separation.
Okay, and Councilor, you have about 30 seconds left. You want to go towards your conclusion, please?
Of course. As a closing remark, consider this. The appellant is suing because if they get denied government aid, they can't send their kids to a Christian education. This means that the appellants rely on government money to send their kids to a religious education. Government funding would be directly responsible for religious education. This should not be permissible under the wall of separation ideology. In alignment with the original intent of no-aid clauses and the strongly related cases of Locke v. Davie and Nyquist, the court should hold the lower court ruling that the Montana Department of Revenue's invalidation of the tax credit program should be constitutional.
Okay.
Thank you, Your Honor.
Thank you. You're right on schedule. All right. We now have 5 minutes of rebuttal for Alyssa and Doris. You can begin whenever you're ready.
I would like to begin with addressing the opposing counsel's argument about the divertibility of funds in terms of, the money that the religious school receives being able to be used for potentially secular aims. And we see here that the two main reasons this is not a key issue is firstly the indirect payment that occurs, and secondly, and most importantly, the levels of private choice involved. And if we look at indirect payment, in Mitchell v. Helms, the court, in its decision, held that the divertibility argument, quote, has only the most attenuated, if any, link to any realistic concern for preventing an establishment of religion, and that it has not accepted the recurrent argument that all aid is forbidden because aid to one aspect of an institution frees it to spend its resources on religious ends, unquote. And so what we see here is that just because potentially some part of this funding can be diverted towards religious means does not mean that is not sufficient reason for this program to be invalidated at all. And
well,
especially
Counselor,
when we look at this issue.
If I can just
Sorry,
interrupt for a minute. Let's talk about James Madison for a second, right? How do you respond to your friend's arguments about Madison's memorial and remonstrance? How do you respond to the argument?
Well, we believe that, even with this scholarship program, we stay well within the bounds of that Madison laid out in terms of maintaining state neutrality when it comes to education.
But is the state being neutral if they're giving money to religious schools? Is the state being neutral?
We contend that the state is being neutral, given that the program is generally available and that people can choose to. It's an issue of private choice. People can choose to donate to organizations that provide religious scholarships to religious institutions, or they can choose to choose an organization that only gives scholarships to non-religious private schools.
Okay, you may proceed.
And so one more note on this issue of private choice. Not only I delineated earlier the many levels of private choice involved, from the individual donors themselves to the scholarship organizations to the parents of the children actually attending the schools. But furthermore, we have to see that when this scholarship program was abolished, what was created was or what was supported was a forced choice in education, because these scholarships were targeted towards the parents of children who could probably not afford to send their children to private schools in the absence of scholarships. Once the number of scholarship opportunities was diminished by the invalidation of the scholarship program, we see that there is a forced choice involved, where these parents now must send their children to public secular schools.
Counsel, let me just come back and discuss it. I think we had this confusion before. The current Montana Constitution the provision was drafted in 1972. I think it wasn't from the 1870s. To what extent should we incorporate the sort of anti-Catholicism from Blaine into this current amendment? Why is that relevant? What happened 100 years ago, if this amendment was passed in the 1970s, where things weren't nearly as bad?
Sure. People, what we can see is that the anti-Catholicism that gave rise to these various Blaine amendments in many states, that maybe that sentiment isn't as prevalent today, but it is being co-opted to continue the suppression of religion.
But there's evidence, your friend said, that ministers and preachers wanted this, that the house of worship wanted this prohibition, right? Why shouldn't we say that this might be good for religion? Why is this a bad thing?
Sure, I'm sure there, for any issue that we can discuss, you can always find someone who is in favor of it and is against it. But what we see is that like the petitioners themselves, when we're looking at the parents of the children who are parents of children who want to send their children to institutions that support their beliefs, we see that there are still plenty of parents like that today.
Okay, and you have 15 seconds left. You want to wrap up briefly?
Sure, Alyssa, do you want to wrap this up?
Sure. Yeah, I would just like to use the remaining time just to distinguish Locke v. Davey from our case. And I would just like to state that the discrimination that the students in Espinoza are faced with, it's forcing them to choose between their religion and receiving financial aid, which is clearly a violation of the Free Exercise Clause. So I would just like to make that last statement.
Okay, thank you so much, Counselor. All right, back to Elliott and Lance. You have 5 minutes of rebuttal. You can begin whenever you're ready.
I think the first point maybe I'd just like to make is that our opponents have been making the point, the distinction between direct and indirect aid, and saying that, okay, this case is different from the other cases we've been discussing because this is indirect aid. But I'd just like to direct our attention to the actual text of the Montana No Aid or Blaine Amendment, which says that legislative counties, cities, towns, school districts, and public corporations shall not make any direct or indirect appropriation of payment from any fund or public fund or monies to any church, school, academy, and it goes on. So I think there we just need to consider that the distinction between indirect and direct aid is not entirely relevant in this case because the Montana No Aid Amendment still prohibits indirect aid. I think I'd also our opponents also said that this invalidating of the school program was specifically targeted towards religious students. That's not true. The entire program was invalidated. No, private school students who are not religious students now can also not get money. No one is getting this funding from the scholarship program, and that invalidation of the scholarship program applies to both religious and non-religious students, not just religious students.
Well, Counselor, I guess this ruling sucks for everyone, right? No one's happy with this ruling, right? Let me ask you a question if I can. In Locke v. Davey, you had funding that was directly to become a minister or basically theological training. Couldn't maybe we salvage this program and say that the money can be used for secular studies but can't be used for religious studies? Isn't there a way that we can maybe leave the Big Sky program in place, but just maybe the court can say, to avoid constitutional problems, we'll read it a little bit differently? Couldn't we read it more narrowly that way?
Well, I think we should look at Lemon for that, because in Lemon versus Kurtzman, then we're seeing that ruling says that there really is, in order to ensure that there was a separation between secular studies and religious studies, that would require the sort of relationship, the entanglement that we've been talking about earlier. And then Lemon especially also notes the impressionable age of primary school students, and noting that makes this distinction that the religious atmosphere even in the secular studies makes it almost impossible to sort of separate the secular aspect from the religious aspect.
Well, Counselor, let me ask you a question. The Lemon test is, almost 30, 40 years old. Has the Supreme Court relied on the Lemon test in recent years?
What was that? Sorry, you cut out.
I'm sorry. Has the Supreme Court relied on the Lemon test much in recent years?
The Supreme Court hasn't relied on the Lemon test as much in certain years. It is 30 years old, and so I do understand that. But I think even if you still look at the cases we've been talking about, such as Committee v. Nyquist, we still see that they're using this sort of the court still is invested in ensuring this wall of separation between the church and the schools, and especially in the schools, they tend to be more stringent in their role plans in ensuring that separation.
Okay. All right, Counselor, you had a minute and a half left, and you proceed.
Lance, would you like to?
Of course, yeah. I'd also like to go back to your original point, your original question, Justice Blackmun. Actually, with my question, it was a point that the opposing counsel made, and it was about this level of private choice. And if we look at Nyquist, in the Nyquist case, the tax relief program was tax relief given to parents who chose where the money went. But even with these two levels of abstraction, the government giving tax relief and not directly paying the schools, and parents choosing where the funding will go, even then, the court ruled that the tax relief system was invalid. And this, again, was because of the use of the money. And that could further religious institutions and their non-secular purposes. And for that reason, the tax relief program was invalidated. And the same fact pattern holds in the case here. Oh boy, I'm not very good at it.
That's okay.
Yeah. So I guess our just last thing is we stick to what we're saying, that Locke v. Davey, these cases we've shown as precedent, shows that invalidating the tax program was not a violation of the free exercise clause, and that even though some states have the power to do tax programs under the establishment clause if they wish, in this case they are not required to do so, and thus invalidating the tax program is not in violation of the free exercise clause, and we hope that the court finds the rules with the original Montana Supreme Court ruling.
Okay, excellent. All right, thank you both very much. That brings this round to a close. Let me say that I am very proud of all of you. You did a fantastic job. I realize my questions are not easy. They're designed to pick little holes in your argument, and if I find even the slice hole, I tear it apart. And I think I was equally tough on both sides. I think this is a hard case. It will probably be a 5-4 decision by the Supreme Court, decided any minute now. Sebastian, is there anything you'd like to add?
No, this was a great round.
Very good. Are there any questions from the attorneys before us? For us, we'd be happy to answer for you. No? Okay. Well, very good then. I will call this round to a close. I think our next round begins in about 10 minutes, so I will end this meeting. I'll start a new one in a few bit. But thank you all so much, and I wish you the best of luck. And if you have any questions, you know how to get a hold of me. Thank you so much.
Nice job, guys.
Thank you.
Thank you, sir.